Hello, everyone, and welcome to the Foul Play YouTube channel. I think we're at open mic number 246, and I guess a little bit of a special event with Zellner's filing with the Wisconsin Supreme Court to see if they will take the case. Now, if everybody remembers, she tried this before when she got denied, and the Wisconsin Supreme Court would not take the case. I don't know how that process is necessarily decided, certainly at the state level nor at the federal level for that matter. So I guess it's kind of a, what would you say, kind of a crapshoot whether they will take it or not. I mean, politically, the winds have changed at the state level. It was shifting from, and I don't really talk about political stuff on our channel, but I think it's okay to say it's switched from Republican control to Democratically controlled. I don't know how long that had been in place. Quite a while, I think. So, um, but whether that has any bearing or any effect, I have no idea. Not a clue. I don't really look at the types of cases and so forth, or even what criteria they even be considered. So, with that being said, I hope they do. I have not read this document. Well, I read a little bit of it, but I wanted to read it raw, kind of like with everyone else at the same time. Um, but she does start out with, talking about how certain things have been applied in error, or, whatever that lawyer speak is. Um, trying to think of prior appeals that she's submitted. It kind of goes along those lines. What, like I read a page or two and then I stopped because I wanted to catch this again with for those that haven't read it. If you hear my granddaughter in the background, she's running around. You could bottle that energy, you know, just a portion of it. I could retire in about 2 days, or just retire. She's a bundle of go get it. I guess that's how it is when you're two and a half. Yeah. So anyway, if you hear something in the background, that's her running around, being crazy. Um, anyway, I guess I'm trying to think if there's anything else here. I guess I could greet everyone. I see there's Mark, Hot Dot from Down Under, Doc from Down Under. Um, welcome. JD, there's Kelly McAlien, Pete Moss, Sheila Hawkins, Passive Bear, Gloria, Steve Dashel, Granny, Crockett. Uh, you know, certainly welcome everyone. We've got, I don't know, I can't hardly tell here. Looks like we got about 40 in the crowd. I know there's people that are joining us from Twitter or X and Facebook. So anyway, I think it's probably just as good a time as any is to go ahead and get started on this document. Now, uh, I'm by myself, so you'll have to bear with me. I'll do the best I can. I don't have that great reading voice of Susan and Sunshine Christine and Doc and some of the others, but I'll do what I can. So as you can see up here at the top, this was filed on the 7th, up here top right, 7th of February. Petition for review. And this, it's Zellner, but it's got Steve Richards also as part of, he's a Wisconsin lawyer, I guess. I think he's been with her for a while. It's got the table of contents and the various things that she goes through in this filing. I really haven't read through these. I scanned it just briefly as I was going through, but it's not a really long document, but I think there's limitations, certain criteria that she has to follow. If it had to be a longer appeal, I think it had to be, you have to submit, something for an extended bird count. Anyway, here's the cited cases that she's got listed. It's a couple of pages here. It looks like, yeah, page and a half. And then we get to the issues. So before I get started, I am drinking coffee, and that's always a plus for me. Coffee is, mm, mm, mm. And I'm trying to drink it. I made it just a few minutes ago, and I was trying to get it drank before I started, but I couldn't do it. Okay. Danny Brewer fan. I'm down under fucking Sheboygan. That's funny. Danny Brewer fan. I would like to see Kate. What's this? I would like to see KZ go big and go after Denny change that precedence. Yeah, they're, filing a Denny as the defendant has to show motive. They have to prove motive, and the prosecutor, the state doesn't have to do that. And I think that's wrong. I think it puts an undue burden on the defendant. If the prosecutor doesn't have to show it at trial when you're convicting someone, why would a defendant have to show motive for someone else? I just don't get it. I just don't. So if anybody could help me understand that. Sorry, got a message here. Oh, no, it's not. Never mind. Okay. Well, I'm going to start reading here. I'll read a certain length, and then I'm going to stop because, well, especially if there's anything that I'm going to remark on as I'm going through that sticks out to me, that's bothersome, or worth mention. Anyway, let's move on. Issues presented. Number 1, whether the Court of Appeals improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of the State v. Edmonds. Gives citation. The trial court held no. The Court of Appeals held the trial court correctly determined that newly discovered evidence would only be material if it was admissible under Denny. Okay. 2, whether the Court of Appeals erred when it did not correctly apply State v. Denny. His citation to Mr. Avery's potential third-party suspect evidence. The trial court held no. The Court of Appeals held the trial court correctly applied Denny to Mr. Avery's potential third-party suspect evidence. 3, whether the Court of Appeals improperly affirmed the trial court's decision to deny Mr. Avery in an evidentiary hearing. The trial court held no. The Court of Appeals held. The Court of Appeals agreed. Criteria for granting review. This case presents, quote, special and important reasons, end quote, justifying Supreme Court review. The Court of Appeals conceded that the Sawinski affidavit establishes, quote, a possible connection between the third party and the crime, end quote, gives the opinion page and the page. Court reached this conclusion by improperly weighing the evidence and imposing an improper burden of proof on Mr. Avery to meet the standard for an evidentiary hearing. This misapplication of the law and misinterpretation of the facts has resulted in a constitutional violation of Mr. Avery's due process rights to present a complete defense at his trial. See Holmes v. South Carolina. I'm going to magnify this just one more time. Hope it doesn't blow it up too big. There we go. Yeah, okay. 1. Issue 1, misapplication of State v. Edmonds and Brady v. Maryland. The first issue concerns whether the Court of Appeals misapplied the standard for evaluating newly discovered evidence on post-conviction, which is governed by State v. Edmonds. He gives the citation there, by restricting Mr. Avery's new evidence to the establishment of potential third-party suspect evidence governed by State v. Denny. In order to satisfy the materiality prong of Edmonds and Brady, even though Mr. Avery offered numerous reasons why this newly discovered evidence is independently material without regard to the Denny third-party suspect standard. Issue 2, misapplication of State v. Denny. The second issue concerns whether the Court of Appeals misapplied the standard for potential third-party suspect evidence set forth by State v. Denny by creating impossible standards for satisfying the motive, opportunity, and direct connection prongs of Denny in a post-conviction pleading contrary to Wisconsin law. The court should grant review because the Court of Appeals decision is in conflict with the court's decision in State v. Denny. Issue 3, misapplication of State v. Balliet. This issue concerns whether the Court of Appeals misapplied State v. Balliet in denying Mr. Avery an evidentiary hearing, and in doing so has deprived Mr. Avery the ability to raise a complete defense in violation of his constitutional rights. The case presents unique constitutional issues based on the Court of Appeals' misapplication of the law and a misinterpretation of the facts to Mr. Avery's case and his newly discovered evidence. Okay, I'm going to break right there and get another drink here before this gets cold. Looks like Kansas has joined us. Welcome, welcome. Okay. Statement of the case. On March 18, 2007, Mr. Avery was convicted of first-degree intentional homicide and a felon in possession of a firearm. He was found not guilty of mutilation of a corpse. He appealed. The Court of Appeals affirmed in 2009. He filed a 97402 motion requiring a new trial. An evidentiary hearing on Mr. Avery's post-conviction motion was held on January 25, 2010. His motion was denied and he appealed. The Court of Appeals affirmed. In 2013, Mr. Avery filed a pro se 97406 motion requesting a new trial. It was denied. On June 7, 2017, Mr. Avery filed a second 97406 motion. The petition was dismissed without an evidentiary hearing. On October 6, 2017, Mr. Avery filed a 97406 motion to vacate, and on October 23, 2017, he filed a motion for reconsideration. The Circuit Court denied his motions to vacate and for reconsideration. I hope I didn't miss a footnote here. I'm going to go ahead and read it. Number one citation. Citations to the record on appeal appear with the document number before the colon and the page number after the colon. Okay, I'm not worried about that. All right, moving on. On October 11, 2019, Mr. Avery filed an appeal. Mr. Avery filed motions to stay and remand concerning 2 additional claims. Mr. Avery raised his claims in his motions to the Circuit Court as supplemental post-conviction motions. The Circuit Court denied his motions to supplement. On April 12, 2021, a new witness revealed exculpatory information impeaching Bobby Dassey by establishing that he had put the victim's car on Mr. Avery's property. Mr. Avery filed a motion to the Circuit Court of Appeals to stay his appeal and remand to allow Mr. Avery to add a claim based on new witness. On July 28, 2021, the Court of Appeals issued a per curiam opinion upholding the Circuit Court's summary denial of Mr. Avery's claims raised in his 97406 petition and two supplemental motions, holding that Mr. Avery's 97406 motions were insufficient on their face to entitle him to a hearing, but reserving his ability to refile his supplemental motion, number 6. On August 16, 2022, Mr. Avery filed his third motion for post-conviction relief pursuant to 97406. Mr. Avery filed an amended motion on December 6, 2022. Mr. Avery's 97406 motion set forth newly discovered evidence that a third party, Bobby Dassey, was seen in possession of the victim Ms. Halbach's vehicle after her disappearance. Mr. Thomas Sawinski contacted the New York Innocence Project about this matter in 2016. Although Sawinski originally believed it was Mr. Avery's trial defense attorneys that he contacted in 2016, after finding an email verification, he realized it was rather the New York Innocence Project he contacted, and thus he amended his original affidavit, which was submitted in Mr. Avery's motion, to stay his appeal to the appellate court, and Sawinski's amended affidavit was filed to the circuit court reflecting this mistake. Affidavits from two other new witnesses in Mr. Avery's case, Mr. Kevin Ramlow and Mr. Thomas Baresh, corroborate Sawinski's observations. We've got another footnote here. I'm going to read it. This is number 2. In Ramlow's affidavits provided to the circuit court, Ramlow described observing Ms. Halbach's RAV4 parked at the turnaround at State Highway 147 and the East Twin River Bridge on November 3rd and 4th, 2005. Ramlow stated that he reported his observations to a Manitowoc County Sheriff's deputy he encountered on November 4th, 2005 at the Cenex it's a gas convenience store, Cenex station on State Highway 147 in Mishkot. In Baresh's affidavit, he states that sometime before 2 a.m. on November 5, he was driving a tow truck in the area of Highway 147 and County Road Q in Manitowoc County and saw a RAV4 driving south on County Road Q, turning left off of County Road Q as it passed him. He recognized Bobby as the driver. He did not recognize the passenger in that vehicle. He is 100% sure it was not Mr. Avery. Okay. Let's pause here one more time. See if I've got anything else to do. There's Mr. President. Welcome. Xenia. Welcome. I hope I'm pronouncing your name correctly. I'll often get them wrong and butcher them, but I promise you it's not with intent. And on the flip side of that, there are people that do mispronounce my name with intent and they add stuff to it. I'm just saying. Being funny here. Okay. That's about done with the coffee. I need to check something here. Give me just 1 second. Okay. Good there. All right. And we are on page 10. In Mr. Avery's 97406 motion, Mr. Avery also raised Brady claims relating to the information from the new witnesses. Mr. Avery attached affidavits and documents showing that after Sawinski contacted Mr. Avery's current post-conviction counsel and provided the newly discovered evidence, Mr. Avery's current post-conviction counsel, through its investigators, submitted a second public records request pursuant to the Freedom of FOIA to the Manitowoc County Sheriff's Office for audio recordings of incoming and outgoing phone calls and a radio dispatch between November 3 and November 9, 2005, relating to the case. The FOIA produced audio recordings did not contain the Sawinski call, nor did they contain any dates or times of the phone calls produced. In May of 2022, Mr. Avery's current post-conviction counsel received the previously suppressed Sawinski call to the Manitowoc Sheriff's Office, which contained a partial recording of the Sawinski suppressed call to the Manitowoc County Sheriff's Office on November 6th. For the first time, current post-conviction counsel received the exact date and time of the Manitowoc County Sheriff's Office incoming calls. Everybody remembers that, don't they? Of course they do. As part of his investigation, Mr. Avery's investigator then interviewed Sawinski's ex-girlfriend, whom he was dating at the time of the November 5, 2005 incident. Sawinski's ex-girlfriend, whom he was dating at the time of the November 5 incident. Okay, I read that. Sawinski's ex-girlfriend, Devon Novak, corroborated Sawinski's account of what he had witnessed and what he had relayed to law enforcement. Further, Ms. Novak recognized and identified Sawinski's voice on the recording played to her by the investigator of a phone call made to the Manitowoc County Sheriff's Office on November 6, 2005 at 10:28 p.m. Mr. Avery's investigator interviewed Sawinski again and played the same audio recording of the phone call that was made to the Manitowoc County Sheriff's Office on November 6, 2005 at 10:28 p.m. Sawinski identified his voice in the audio recording of the phone call from November 6. Scroll that up. The recording of Sawinski's call was never disclosed by the state to Mr. Avery's trial defense counsel prior to or during trial. Pre-trial defense counsel made two specific requests for all exculpatory evidence and or information within the possession, knowledge, or control of the state which would tend to negate the guilt of the defendant or which would tend to affect the weight of the credibility of the evidence used against the defendant, including any inconsistent statements. The failure to disclose the audio call to trial defense was a clear-cut Brady violation. I'm going to agree with that. You don't hold something for 15 and a half, 16, whatever years and say, oh, well, look what I found. An additional Brady claim stems from the evidence from the Ramlow. Ramlow described in his affidavit that he reported his observations of the RAV4 parked away from the Avery property to a Manitowoc County Sheriff's deputy he encountered on November 4, 2005 at the Scenic Station on State Highway 147 in Mishkot. No law enforcement report was ever generated by this Manitowoc Sheriff's deputy memorializing the conversation between Ramlow and this deputy about Ramlow's observation of Miss Halbach's vehicle. The circuit court denied Mr. Avery's motion for post-conviction relief on August 22, 2023. Mr. Avery filed a timely notice of appeal on August 24, 2023. On January 15, 2025, the Court of Appeals issued a per curiam decision affirming the circuit court's denial of Mr. Avery's claims. Mr. Avery will accept the facts as stated in the Court of Appeals opinion on pages 2 through 8. Okay. Just check right quick for any comments. Hey, there's Clive. Haven't seen you around in a while, Clive. Maybe I just missed you. Little Barb. Okay. Danny says, was the defense given the other call records of tips that came in before the trial so they could run down some of these tips? I'm sorry. I got to tell you, Danny, I'm not sure of that. I've never had a conversation with Buting. I've talked to him well, I've texted with him, but I can't. I don't know that. It doesn't sound like something that we knew anything about, but that doesn't mean anything. You know, Pete Baez was their investigator for off and on. I mean, they didn't have a lot of extra money, so they couldn't really utilize him to his fullest degree. But you know, he did run down some things, but I just don't remember them actually having, you know, a tip sheet with one or, you know, several names for that matter. I don't for any reports generated during the free trial. Doesn't mean that didn't happen. It could have. They could have requested it and it could have been handed off. So I don't know, maybe somebody else out there has more knowledge of that than I do and can answer. I mean, Pete did, you know, he did find out some very interesting things, which I'm not going to get into right now. But you know, one of them was about Avery's stay in the Calumet County Jail, and that one bailiff or whatever you want to call him, jail staff, told Pete that, you know, everything in here is recorded anyway. It doesn't matter what you do, because Baez had went to go see Avery, and they were going to force him to talk through the glass, and he's like, "No, everything's recorded. I'm not. I'm a defense investigator. I'm not doing that. I don't need to do it." And that guy told him, "You know, it doesn't matter. No matter where you're at, you're recorded anyway." Well, it turns out that's true. I mean, that video that Kratz revealed that we knew nothing about. No one did. No, he did, obviously. So, anyway, Miss O.P. He was really liked his hearing him speak and Making a Murderer. A very matter of fact, you kind of know where you stand kind of guy. I like that, but not. I mean, not a jerk. I mean, I never got that. Just a very matter of fact and frank person. Anyway, listen, guys, if there's any questions, I'm kind of flying solo here. If there's any questions or something you want me to that you see in this document that you want to talk about, please put it into the chat. Put a Q in front of it. I'll just, when we take a pause here, I will certainly take a look here. Anyway, let's move on. Argument number one: whether the appellate court improperly imposed a burden on Mr. Avery to conclusively prove the Denny motive element in order to satisfy the materiality prongs of the State v. Edmonds, and Brady v. Maryland. Standard of review: the state's highest court will not disturb a circuit court's decision to admit or exclude evidence unless the circuit court erroneously exercised its discretion. A circuit court erroneously exercises its discretion if it applies an improper legal standard or makes a decision not reasonably supported by the facts of record. State v. Jackson. Imposing improper standards on newly discovered evidence. Both the Circuit Court and the Court of Appeals impose an improper standard in evaluating Mr. Avery's newly discovered evidence. The Court of Appeals found, quote, the Circuit Court properly recognized Avery's newly discovered evidence was not independent from Avery's attempt to meet Denny and addressed whether the evidence was material within the confines of his third-party perpetrator argument, end quote. Here's the opinion page. Both lower courts improperly merged two standards into one in order to deny Mr. Avery's newly discovered evidence. The merging of the two different standards, that in Edmonds and that in Denny, allowed the lower courts to base the materiality of Mr. Avery's evidence on proving that Bobby had a sexual motive to kill Ms. Halbach and also prove beyond a reasonable doubt that he alone made every single pornographic search on the Denny computer. The lower court's analysis completely ignores that the Sawinski evidence is independently material for numerous other reasons besides proving that there is a third-party suspect for the murder of Miss Halbach. And I'm going to pause here, and I'm not going to get too mouthy, I promise. But this is one of my big problems, and it's kind of happened a few times in this case. Is that to me, the circuit court and the Court of Appeals acts like that the RAV4 is not evidence at all. They want to talk about, well, no one saw Bobby with it. Or again, we can leave Bobby's name out of it. It doesn't matter who had possession of that freaking car, and you can just change freaking to something else. Hey, there's my neighbor, True Crime Fangirl. Anyway, it doesn't matter who had possession of that vehicle. They're trying to justify saying, well, nobody saw this person with their keys, the electronics, meaning her Palm Pilot, or whatever. Like that somehow removes the RAV as evidence itself. The most important piece of evidence in the case, in my opinion. It is the single most important. Everything started with that RAV when they found it, remember? Everything blew up. Everything. So anyway, before I get on my horse here, I'm just saying, how did they completely ignore the RAV? I don't understand. And they did. You've got somebody, again, you can leave Bobby or whoever else's name out of it. It's an entity, a human, has possession of this victim's car a day, maybe whatever, I guess heading towards 2 days after she's reported missing. Like that doesn't matter. Like that doesn't require some discussion to force an answer, force a statement, something in court that's legal. I just don't understand it, and I haven't gotten an answer yet. No one has been able to say, well, this is why the Court of Appeals and the Judge Angie's standard to get anything done, but she imposed an impossible task, and again, it's because, well, number one, because of this, that like the RAB doesn't exist. It's not evidence. They're relying on the other stuff, the materiality stuff. I'm saying Teresa's possessions. Well, her car was her possession. It drives me crazy, man. That's okay, True Crime. True Crime Fangirl, you haven't really missed a lot. She's just laying out stuff that's happened in the past, and now we're getting into the meat of her of this appeal. Anyway, okay. Yeah, okay. In Mr. Avery's third motion for post-conviction relief, Mr. Avery explained how his new evidence was independently material from demonstrating a Denny third-party suspect. Specifically, he argued the Sawinski evidence is material to several issues in Mr. Avery's case. It is material for establishing Mr. Avery's defense, that is, that a third party committed the crime against Miss Halbach. Additionally, the Sawinski evidence is material to the evidence in the RAV4 being planted by Bobby, including Mr. Avery's blood and DNA. The RAV4 also contained the Halbach vehicle key and Miss Halbach's electronic devices, which were discovered in Mr. Avery's bedroom and burn barrel, respectively. Further, the Sawinski evidence is material to impeach Bobby's trial testimony that Miss Halbach never left the Avery property and that she was last seen walking towards Mr. Avery's trailer. The Court of Appeals avoided addressing this independently. Let me start again. The Court of Appeals avoided addressing this independently independently material evidence by inaccurately claiming, quote, Avery only analyzes Sawinski evidence within the context of a third-party third-party perpetrator defense, end quote, opinion, page 10. The Court of Appeals pointed out in paragraph 4 of its opinion from July 28, 2021. The state's theory was that Avery shot Halbach in the head in his garage and threw her in the cargo area of the RAV4. He then burned the electronics and camera, cremated Halbach in a burn pit, transferred the remains to a burn barrel, and hid the RAV4 until he could crush it in the Avery car crusher. Hid the RAV4? Are you kidding me? Okay, I'm not getting on that horse. Moving on. Mr. Avery argued that Sawinski's new evidence is material because it shows that the RAV4 did leave the Avery property and was in possession of a third party, not Mr. Avery, thereby debunking the state's theory that Mr. Avery had exclusive possession of the vehicle and the forensic evidence contained therein, and that he kept the RAV4 on the Avery property by the crusher so he could crush it immediately. The prosecutor, in his closing argument, told the jury that, quote unquote, only one person was responsible for the crime, and that was Mr. Avery. As Mr. Avery argued, the evidence of a third-party possession of Miss Halbach's vehicle is additionally material because it shows that someone other than Mr. Avery had possession of the forensic evidence used to convict Mr. Avery. The vehicle, by the virtue of having all the relevant forensic evidence in it, including Miss Halbach's blood, was the most important piece of evidence in the case. I agree. In his closing, the prosecutor said, quote, because the discovery of that RAV4, the discovery of Teresa Halbach's vehicle, changed the course of not only this case, but the clues and secrets found in that vehicle changed the lives of everybody in this room, end quote. The prosecutor emphasized to the jury that, quote, nobody had access to the car, end quote, and, quote, no one was going to tamper with that SUV after it was located, end quote. However, the Sawinski evidence establishes that Bobby, the state's primary eyewitness, had access to and the ability to tamper with the vehicle before it was located. Mr. Avery was entitled to have presented this critical fact to a jury, and not being allowed to do so deprived him of his constitutional right to present a complete defense. Despite police searches preceding this discovery of Miss Halbach's vehicle, Miss Halbach's electronic devices and key were not found until after Miss Halbach's vehicle was found. The only reasonable inference is that all the items remained in Miss Halbach's vehicle and were then moved by the third party who had possession of her vehicle and planted it around Mr. Avery's residence. If a third party had possession of Miss Halbach's vehicle, numerous areas of reasonable doubt arises, such as that the forensic evidence in the vehicle was tampered with by the third party having control of it before it was discovered by law enforcement on the Avery property. This would have created a reasonable doubt in the jurors' minds, particularly since the state's primary eyewitness was the one in possession of the vehicle. Thus, Mr. Avery's new evidence also presents an alternative theory for the source of the forensic evidence used against Mr. Avery. See Edmonds. Importantly, Mr. Avery also argued that the Sawinski evidence impeaches the credibility of Bobby's trial testimony, where he established an alibi for himself while implicating Mr. Avery in the murder. In fact, Mr. Avery spent numerous pages on his third motion explaining the impeachment value of Mr. Avery's new evidence. Bobby testified that he left the property while Ms. Halbach and her vehicle remained on the property with Mr. Avery. This crucial testimony allowed the state to claim it was Mr. Avery, not Bobby, who murdered Miss Halbach and concealed her vehicle on the property. During its closing argument, the state emphasized the importance of Bobby's testimony, vouching for his credibility. Quote, again, an eyewitness without any bias. It is that deserves to be given a lot of credit, end quote. With the new Sawinski evidence, the state could not possibly have presented an unimpeached Bobby to establish Miss Halbach never left the property in her vehicle, and that she was last seen walking towards Mr. Avery's trailer. Its critical eyewitness linked to obtaining Mr. Avery's conviction. Bobby was the only witness whose testimony the jury required to, quote, read or hear a transcript of, end quote. Remember, they requested Bobby's trial testimony and Wills denied it. Clearly, by Bobby possessing the vehicle, there is a reasonable likelihood it would have affected the judgment of the jury and that Bobby would have emerged as a much more likely suspect in Miss Halbach's murder than his recently released, wrongfully convicted uncle, contrary to the state's representations to the jury. Bobby was biased and he deserved no credit for his fabricated testimony. All right, I'm going to pause there for a minute. I got to get a drink. I can hear the frog coming in my voice. Okay, let's see if we've got any questions here. Oh, Clive's got to go. I imagine it's pretty late where Clive is at. You know, I can't think a lot of. It's difficult, to get a time slot because we got people listening in all over the place. I mean, it's kind of crazy to think about. People listening from basically all over the world. I don't know. I looked at it on YouTube one time. I think it was 19 countries we've had people listening in from. Pretty crazy to think about. I mean, me personally, I never even thought about that kind of thing before I even, was on air for the first time about the case with Eric Cozy. Sorry, had a message here, and I think I've got another one here. Guys are gonna have to bear with me, and I do apologize, but real life always just it just kind of keeps trucking, even during the live. Believe it or not. Okay. All right, got that. Okay. I had one more thought in my mind, but that thought has evaporated, whatever it was I was thinking about. Okay, well, maybe it'll come back. All right, let's move on. We've got, it looks like about 16 pages, but I doubt, I'm gonna imagine there might be some fluff at the end. I don't know. We'll see. Anyway. In regard to a motion for a new trial, reasonable doubt as to the defendant's guilt has been found to exist when the credibility of a witness critical to the state's case is completely called into question by newly discovered evidence. State v. Wilson. Quote, a new trial is required if the false testimony could, in any reasonable likelihood, have affected the judgment of the jury, end quote. Giglio v. United States, citations omitted. See also State v. Plude. Okay, let's got a quote here. Quote, Wisconsin law has long held that impeaching evidence may be enough to warrant a new trial, end quote. In State v. Plude, the defendant presented newly discovered evidence that an expert witness lied about his credentials. The Supreme Court of Wisconsin found that because, quote, the expert's testimony was a critical link in the state's case, end quote, quote, his quasi-medical expert testimony creates a reasonable possibility that the jury, hearing of his false testimony about his credentials, would have had a reasonable doubt as to Plu's guilt, end quote. Notably, in Justice Annette Ziegler's concurrence, she found that the new allegations that the expert's witness misrepresented his credentials created a serious question as to whether the interests of justice were served. Mr. Avery presents a stronger case about the materiality of his newly discovered evidence because his evidence shows that Bobby committed perjury in his trial testimony, and it taints all of the forensic evidence used against Mr. Avery, which resulted in his conviction. Prior to the Sawinski evidence coming to light, the Court of Appeals assessed Bobby's testimony as follows. Certainly, this testimony bolstered the state's theory that Halbach visited Avery on this day and did not leave the Avery property thereafter. But absent this testimony, the state still possessed significant forensic and other evidence implicating Avery in a crime committed on his property. However, in Mr. Avery's third 9746 motion, he brought forth newly discovered evidence that does both. It completely impeaches Bobby's testimony while casting doubt on all the forensic evidence used against Mr. Avery. Thus, Mr. Avery has shown how his evidence is highly material, independent of establishing Bobby as a third-party suspect. Besides requiring Edmund materiality to be solely based on being able to meet the Denny requirements, the Court of Appeals erroneously found, quote, Avery did not offer any analysis that explained why his newly discovered evidence was not cumulative outside of his third-party perpetrator defense, end quote. However, even if there were multiple examples of Bobby's impeachment for purposes of a Brady claim, the court is not to view each piece of suppressed evidence in isolation. Instead, the court is required to assess the cumulative impact of all the suppressed evidence to determine its materiality. There's quotes, case cited there, Kyle's v. Whitley. Just to touch just a little bit on that comment or that passage there. This is something that is truly bothersome for me personally. I know not everyone looked at these cases in the same light, but this is a real problem for me. And this goes back basically to the beginning of when I really, was jumping both feet into this case back in early 2016. And then we really began to find out how much was really withheld from the jury and really how much was withheld from the defense. I mean, we know far more than any of them knew at this point. Far more. Of course, it's all come out. But in 2000, well, let's just say 2006. I mean, I kind of count 2005, but nothing against Eric Loy, Avery's first lawyer, but to me, there were things that he should have done. Now, I know public defenders are overwhelmed, and I'm not going to get into all that, but even when Buting and Strain took over in early 2006, there was so much that they were never given. So much, some of it critical. Whatever the blunt and bloody instrument is, it doesn't matter if it's that tire tool that was found back there from that emergency roadside kid and somebody wiped it off. Well, who the hell wiped it off? Why wasn't it tested? If it was something else and it was removed, where the hell is it? Something not jiving there. To me, this was a critical thing, and there have been other ones too. And I'm 100% convinced there's more that's never been revealed. Never. Does it for a voicemail? It appears in Mr. Kratz's exhibit list weeks before trial. And I mean a few weeks, no more than 4, because it was January 2007. but he has no idea where it's at. How's that work? Why would he include it in his exhibit list? Come on, man. The flower video. Come on. People say, well, the guilt or side say, that's not edited. Well, of course it's edited. Of course it is. You've got video shot number one. At the end of it, you've got this video in the burn pit showing a few tiny bones of some type. We don't know what they are. That's at the end of the November 4, November 5 flyover. There's no flyover footage from the Zipplers at all or any other area except the Averys. So did they not shoot video of these other areas like one would think if they're actually looking? Or did they video it and then cut it out? Which is what I think happened. Anyway, I'm going to get off that horse and we're going to get back on. Starting right there. Okay. The continual effort to move the goalpost to thwart Mr. Avery's post-conviction efforts by employing the use of per curiam opinions, which blatantly violate his constitutional right to present a complete defense, cannot and should not be condoned. Yeah, again, this per curiam stuff. We've seen this numerous times with the Court of Appeals. Basically, an unsigned opinion, I think is what it is, and can't be used, can't be cited for other cases. That has a big question mark on it for me, because it sounds like we have the power to deny you, but we're not going to base it on anything that is more legally empowering. So you can't cite this case for other cases. It's just got a big stink about it. I just don't get it. Anyway, further, contrary to the Court of Appeals assertion that, quote, Avery did not offer any analysis that explained why his newly discovered evidence created a reasonable probability of a different outcome on retrial that was independent from Avery's attempt to meet Denny and addressed whether the evidence was material within the confines of his third-party perpetrator argument, end quote. Mr. Avery's third-party 97406 motion and briefs on appeal thoroughly analyzed why Sawinski evidence is independently material and would have created a probability of a different outcome on retrial. Get some citations there. Mr. Avery has not waived his Brady and interest of justice claims set forth in his petition. In Mr. Avery's third 97406 motion, Mr. Avery raised Brady claims relating to this information from the new witnesses and also raised an interest of justice argument. As for his first Brady claim concerning the suppression of the Sawinski evidence, Mr. Avery attached affidavits and documents showing that after Sawinski contacted Mr. Avery's current post-conviction counsel initially, obtained FOIA produced audio recordings which did not contain the Sawinski call, nor did they contain any dates or times of calls provided. Then, in May of 2022, Mr. Avery's current post-conviction counsel received a partial recording of the suppressed Sawinski call to the Manitowoc County Sheriff's Office on November 6. Sawinski's ex-girlfriend, Devon Novak, recognized and identified Sawinski's voice on the recordings of Sawinski's phone call made to the Manitowoc Sheriff's Office on November 6, 2005 at 10:28 p.m. Mr. Avery's investigator interviewed Sawinski again and played the same audio recording of the phone call, and Sawinski identified his voice in the audio recording of the phone call. The recording of Sawinski's call was never disclosed by the state to Mr. Avery's trial defense counsel prior to or during the trial. If the call had been disclosed, Mr. Avery's trial defense counsel could have traced the call to Sawinski by subpoenaing the phone numbers. Mr. Avery sufficiently pled his Brady claim concerning the Sawinski evidence in his motion for post-conviction relief. And this was not the issue disputed by the circuit court in denying his claim. The circuit court did not make any finding that Mr. Avery did not sufficiently plead his Brady claim. Rather, it disputed Mr. Avery's argument regarding the materiality of the evidence. In regard to the Brady claim stemming from the evidence provided by Ramlow, he described in his affidavit that he reported his observation of seeing the RAV4 to a Manitowoc Sheriff's deputy he encountered on November 4, 2005 at the Cynic Station on State Highway 147 in Mishkot. No law enforcement report was ever generated by this Manitowoc Sheriff's deputy memorializing the conversation between Ramlow and this deputy about Ramlow's observation of Miss Halbach's vehicle. Again, Mr. Avery sufficiently pled his argument in his motion for post-conviction relief. The circuit court did not find out otherwise, but rather it disputed the materiality of this evidence. The appellate court completely overlooked the Ramlow evidence. Mr. Avery properly pled his interest of justice claim in his motion. However, applying the same rationale for denying his Brady claims, the circuit court found that, quote, the defendant asked that the court grant him a new trial in the interest of justice pursuant to Wisconsin statute 805.15. Given the above conclusions reached with respect to the evidence offered by the defendant, there are no legal grounds to grant such a request, end quote. The Court of Appeals ignored Mr. Avery's actual pleading and circuit court's rationale for denying Mr. Avery's evidentiary hearing, and improperly found that Mr. Avery's Brady and interest of justice claims were waived on appeal because it claimed that Mr. Avery did not argue that the Brady and interest of justice claims were sufficiently pled. Opinion page 8. However, this ignores the fact that the circuit court never found that Mr. Avery's claims were insufficiently pled. Rather, the circuit court accepted that they were properly pled, but concluded that Mr. Avery's evidence that was suppressed was not material, and for the same reason denied his interest of justice claims. Following the circuit court's rationale for denying his claims, Mr. Avery properly raised the issue as to the circuit court's misapplication of Brady to his newly discovered evidence on appeal. Mr. Avery argued on appeal that the circuit court misapplied the law and required Mr. Avery to also prove Denny in order to satisfy the materiality prong for satisfying Brady. In Mr. Avery's brief, Mr. Avery pointed out that in evaluating Mr. Avery's Brady claim, the circuit court did not dispute that the prosecution had suppressed the audio recording of Mr. Sawinski's call, but that rather it disputed the materiality and favorability of the evidence. Mr. Avery argued that the circuit court's manner in determining Mr. Avery's evidence was not material and was improper because, as argued multiple times, the evidence is material for reasons outside of Denny, including for its impeachment value. Of course it is. Mr. Avery could not have waived his Brady claims because they are within his argument that the circuit court improperly imposed a burden for him to also satisfy a Denny requirements in order to show that his evidence is material for bringing his constitutional claims, which obviously encompasses his multiple Brady violation claims. Because Mr. Avery has not waived his Brady claims and argued on appeal that the circuit court improperly held him to an improper standard for evaluating materiality, and the Court of Appeals improperly dismissed his claims as being waived. This court's review is required to adequately resolve the issue. Additionally, because the Court of Appeals affirmed the Circuit Court's misapplication of the law in evaluating Mr. Avery's newly discovered evidence and Brady claims, this court's review is required. Let's pause here at number 3. We'll absolutely have to have some water here. Hey, look, he's there. My God. Alice is in the house. Oh, my God. Hope you're doing well, Alice. Great to see you. Yeah. I know it's a little late over there, but it's really not that late. By our standards are different. Okay. You know, we kept you up to 5 a.m. a couple of times. So it's really kind of early if you look at it that way. Yeah, I know. Just reading the comments over here. Sheila says Stephen couldn't keep this day straight before all of this happened, much less under stress because knowing they were out to get him. He argued to Jody about a certain day on a jail call. We've talked about this at length, and without a slide against anyone on the Avery salvage yard, none of them had good memories. Not one, not a single one. And that's just the way it is sometimes. It's and when you move out months later, I dare anyone months later without having some kind of something documentation or having an event memorialized, you're not going to remember properly. You're not. That 1 in 100 or whatever the number is that have a super sharp memory. And I'm not bragging, but I used to have one. I had a really good memory. It's not gone, but it is certainly not as good. Not Doc and I are not quite spring chickens anymore, so it's not as sharp as it was. But there's just no way. Even with the kid, some kids they just don't have good memories anyway. That's just it's just the way it is. Some people in general, their memories are terrible. So you take these events, weeks, sometimes even days, but you get weeks out, you get months out. You're gonna muck it up. I promise you, you're gonna screw it up. Especially the mundane tasks that we do. Maybe not every day, but often. Once a week, once every couple of weeks, you're going to screw something up in remembering that event. That's right, Crockett. Misremembering something is not lying. You just hosed it up, and it's not a videotape. Like Fassbender kept telling Brendan, "Play that tape in your head, Brendan. Play that tape." Look, dumbass, and I'm speaking to Fassbender. It's just that's not what it is. Yeah, they really did, Doc. They really did. All right. Let me check one more place here. Okay. And I apologize. There's things that I normally do in the background that I can't do necessarily when I'm reading. All right. That's okay. And is that okay? Yeah. Okay. That's working. There's things that I do in the background a lot of times when Doc or Susan or somebody else is talking. I can't do when I'm reading, so I'll pause. I apologize for that little pause there or break. Anyway, let's move on. Number 2, whether the Court of Appeals erred when it did not correctly apply State v. Denny. to Mr. Avery's potential third-party suspect evidence. Standard of review. The appellate court generally reviews a trial court's decision to admit or exclude evidence under an erroneous exercise of discretion standard. State v. Wilson. However, when a defendant's constitutional right to present a defense is implicated by the exclusion of evidence, the decision not to admit the evidence presents a question of constitutional fact that the appellate court reviews de novo. State v. Ramsey. Mr. Avery provided sufficient facts to meet the Denny requirements in his third 97406 motion. In Wisconsin, Denny governs the admissibility of potential third-party perpetrator evidence. Denny requires a showing that, quote, there must be a legitimate tendency that the third-part person could have committed the crime, end quote. State v. Denny. A legitimate tendency is demonstrated where the defendant can present 1, the motive, 2, opportunity to commit the charged crime, and 3, provide, quote, some evidence to directly connect a third person to the crime charged, which is not remote in time, place, or circumstances, end quote. In deciding Mr. Avery's previous appeal of his second motion for post-conviction relief, the Court of Appeals specifically instructed Mr. Avery about the following. As discussed below, we are not addressing Avery's most recent filing to this court. See our discussion on motion number 6, which seeks to directly connect Dassey to Halbach's murder. If Dassey wishes to raise that claim, he will need to bring a new Wisconsin statute 97406 motion. That motion would need to survive both Escalona-Nerano scrutiny and be found to have merit, in which case the evidence presented might supply the missing direct, quote-unquote, direct connection. In that event, the VLCD evidence might become relevant to showing Dassey's motive and might bear on whether Dassey is or should have been a viable Denny suspect. We express no opinion on the merit of any such 97406 motion, as all such issues would be for the circuit court to decide in the first instance. Okay. Seemingly having forgotten that it previously found that the VLCD evidence might become relevant to showing Dassey's motive if Mr. Avery's third 97406 motion showed, quote, the missing direct connection, end quote, the Court of Appeals decided to adopt the circuit court's convoluted and faulty analysis of what is required to satisfy the Denny test. Both lower courts improperly elevated the motive prong to the most important of the 3 prongs and imposed an impossible burden to meet in requiring each element, motive, opportunity, and direct connection, to be considered or to be conclusively satisfied. Mr. Avery pled sufficient facts to establish that Bobby had a motive for the murder. In Mr. Avery's third 97406 motion, he alleged that the motive attributed to Bobby for Ms. Halbach's murder could have been sexual and provided evidence supporting this, namely the suppressed evidence from a computer that was in Bobby's bedroom. Further, Mr. Avery supplied evidence showing that Bobby was the primary user of this computer, according to his brother Blaine, whose affidavit Mr. Avery attached. Mr. Avery also showed that Bobby lied to the police about the location of the computer, claiming it was in the living room, but crime scene footage showed it was in his bedroom. Mr. Avery supplied this additional evidence to the circuit court in his third 97406 motion, even after the Court of Appeals had previously acknowledged that the potential materiality of the BLCD in proving a third-party suspect. The circuit court's finding and the Court of Appeals affirmation, contrary to its prior finding that the BLCD could serve to show Bobby's motive if Mr. Avery supplied direct connection evidence that Mr. Avery has not established the motive element of Denny is contrary to Wisconsin law. Wisconsin cases that discuss the motive element of a Denny analysis show that the standard for fulfilling the motive element of a Denny is not overly burdensome, especially when there is strong evidence of a third-party perpetrator direct connection to the crime. For example, State v. Ramsey is a case in which very weak evidence motive against a third party was presented by the defendant. However, the appellate court found there was strong evidence of a direct connection, and thus it found quote-unquote plausible reasons for the third party to commit the crime. In Ramsey, the victim was found stabbed at a home. The 911 caller told police that the victim had been staying at her sister's home to hide from the defendant. The defendant had been in a relationship with the victim for over 11 years, and they had 2 children together. They had a history of domestic violence. Officers found the defendant, and the defendant admitted stabbing the victim twice. The victim's best friend told the police that the day before the stabbing, the victim told the defendant that she was going to leave him. After fingernail clippings from the victim revealed another man's DNA, the defendant brought forth a Denny motion arguing that a potential third-party perpetrator was a convicted criminal. 1, a convicted criminal. 2, lived near the crime scene. And 3, his DNA was present at the scene and is unexplained. The defendant alleged 2 possible motives for the third-party perpetrator: irrational rage and antisocial behavior and/or sexual gratification. The defendant argued that it was possible that the third party had no rational motive. Thus, the defendant presented evidence of a general motive which was not directed at a particular victim. In Ramsey, the circuit court found that the defendant had failed to establish third-party motive and denied the motion. However, the appellate court reversed the circuit court's ruling, stating, quote, "We conclude that when considered under the applicable law regarding motive, with the opportunity evidence and the strong direct connection evidence, Ramsey has presented a plausible reasons for third party to commit the crime," end quote. The appellate court found that under the totality of the circumstances, the evidence suggests a third party perpetrator actually committed the crime, emphasizing that suggest is a rather broad term. Mr. Avery, in his non-746 motion, presented far more evidence than is even required to suggest that a third party actually committed the crime. The lower court's failure to consider the Denny prongs in the aggregate, and their erroneous impositions of a burden of substantial certainty on Mr. Avery's motive evidence to prove beyond a reasonable doubt that Bobby conducted each search is a reversible error. Bobby is the only person who has been identified as having taken unlawful possession, theft of the victim's vehicle, and had an abundance of violent porn of young women on the computer in his room, for which he has been described as the primary user. Combined with these damning facts is his role as a primary eyewitness against Mr. Avery at his trial. Mr. Avery has offered even further evidence of motive, which Sowinski evidence, because it shows that Bobby had possession of Miss Halbach's vehicle. If not sexual, Mr. Avery even offered another potential motive for Bobby. After obtaining the Sowinski evidence that Bobby was in possession of Miss Halbach's vehicle, a vehicle that he unlawfully obtained. It is only logical to conclude that Bobby's motive could have been theft. The Court of Appeals contended that the theft motive was not properly pled in Mr. Avery's motion, but it was by the submission of an eyewitness account by Sawinski that he saw Bobby in possession of Miss Halbach's vehicle after her disappearance. Sawinski supplied sufficient detail that this was a theft. Mr. Avery's evidence satisfies the direct connection element. Court of Appeals, in an argument that strains credibility, claimed that the RAV4 that Sawinski witnessed was not necessarily Miss Halbach's vehicle in order to dismiss Mr. Avery's direct connection evidence. Specifically, the Court of Appeals disputed that the RAV4 belongs to Ms. Halbach, finding the Sawinski, affidavit, however, only stated that Sawinski saw Bobby and another individual pushing a blue-colored RAV4 on November 5, 2005. Apparently, the appellate court believes that Sawinski was required to obtain the VIN number of the RAV4, oh my God, and that he observed to rule out the completely improbable scenario of Bobby pushing another blue-colored RAV4 onto the Avery property on November 5, 2005 in the early morning hours. Under the Court of Appeals, the Circuit Court correctly acknowledged, quote, the Sawinski affidavit taken as true for the purposes of this motion directly links Bobby to the possession of the victim's vehicle, end quote. The Court of Appeals rationale is incorrect, as it did not take Mr. Avery's pleadings to be true. In State v. Williams, the appellate court found a direct connection between an individual and the murder because it had possession of the victim's vehicle several days after her murder. Specifically, the court explained, we agree with the state that from all these circumstances, under a common sense, non-technical approach, a reasonable police officer would draw the reasonable inference that both Williams and Armstead had been in possession of a brown stolen car. There was probable cause to believe that both Williams and Armstead probably had committed a crime involving the murder victim's stolen car. Applying this common sense approach here, the Sawinski evidence provides the direct connection, that is, Bobby being witnessed in possession of Miss Halbach's vehicle, to Bobby having committed the murder of Miss Halbach and planning the evidence to frame Mr. Avery. We got a footnote coming up. The RAV4 is a material piece of evidence in the crime. Key state, I don't know what that is, citation. Since the only similar Wisconsin case on this point is State v. Williams, this court can look to the Missouri case for guidance. The state presented other explanations for the discovery of material evidence. The court rejected that approach, stating, state argues that Ted Helmig's initial possession of some of the canceled checks and their later discovery with the purse only shows an attempt to cover up Dale Helmig's crime. That may be true. However, the fact that there may be other explanations for the discovery of the canceled checks with the purse besides, and I don't know if that continues or not. Besides, and it does not continue. All right. On the footnote, Mr. Avery realizes that this case existed 2 months before it would have had precedential value. The court's common sense approach is instructive. Oh, maybe this continues at the top of the next page. I apologize. That may be true. However, the fact that there may be other explanations for the discovery of the canceled checks with the purse besides are inference that Ted Helmig threw the first and the cancel checks in the river sometime following his murder of Norma Helmig does not relieve us of the obligation to acknowledge that Ted Helmig has now been connected to the purse, material evidence in Norma Helmig's murder case. Okay. The Missouri court found that Ted Helmig's mere possession of the canceled checks was sufficient to connect him to a key piece of evidence in the crime, the first where the canceled checks were found. Here, the circuit court admitted that Mr. Avery's established Bobby's possession of the RAV4, but it created other explanations other than acknowledging that Bobby had possession of the RAV4 sometime following his murder of Miss Halbach. Bobby is now connected to the material evidence in the Teresa Halbach murder case. The Denny test only requires an inference that Bobby is directly connected to the murder of Miss Halbach, nothing more. By having possession of Miss Halbach's vehicle after her disappearance, the inference can certainly be made. The Sowinski evidence is being offered as evidence of the quote-unquote missing piece, the direct connection between Bobby and Miss Halbach's murder. Contrary to the lower court's positions, Mr. Avery does not need to prove Bobby's guilt of the murder beyond a reasonable doubt. See House B. Bell. I'm going to take a short break here and get a drink. We're at the home stretch here, it looks like. Hey, I'll see Travis. Thanks for coming, Travis. Good to see you. I see Tom Pedden. I don't know that I recognize that name. I see Yoga. Hope you're doing okay. I'm going to scroll up here and see if I see any questions while I'm sipping this water. It looks like there's some good conversation rolling, but I don't really see any questions. Check some background stuff here while we're... Okay, that's going okay. Yep, going okay. Yeah, we should be okay there. Just I don't know what your all thoughts are, but to me, Zellner is breaking this down pretty well in a not an overly complicated way about what she sees as error by of course, the circuit court and the Court of Appeals. There are a couple of elements, and again, I'm not a lawyer. I don't see this stuff on the daily like Travis probably does, and maybe even some others out there listening that are in court and watch the process. And understanding, that I totally agree that we should have no nonsense judges, but it has to be no nonsense for both sides, right? How someone, again, I don't have to use the word Bobby. It could be anyone having possession of someone else's vehicle that has been reported missing and is later found. I think the book of us agree that Teresa's gone, she's dead, and that doesn't raise the antenna. Just that alone, got possession of the vehicle. Someone saw you with possession of that vehicle, and they go this route of around the bend, up the mountain, back down over here, to completely ignore that piece of evidence, this gigantic piece of evidence, instead of relying on the electronics, the keys. They didn't see her with keys, didn't see her with her phone and her tablet or whatever, the Palm Pilot. So therefore, I don't understand it, and I want to understand it. But I think the reason I can't understand it is because it doesn't make any sense at all. Um, there's Corey. Good to see Corey. Okay. Sorry for the silence. Had some messages here I needed to answer. Okay. I'm going to continue on here. We've got about 6 pages. It looks like 5 or 6 pages, something like that. All right. Mr. Avery showed that there was a reasonable probability that presenting Mr. Avery's newly discovered evidence undermines confidence in the outcome of Mr. Avery's trial. Mr. Avery has adequately shown how his newly discovered evidence would have changed the outcome of the trial. The new evidence would have allowed the defense to impeach Bobby's trial testimony. During his closing arguments, Prosecutor Crafts emphasized the importance of Bobby's testimony and vouched for his credibility. We talked more about the timeline and we heard from Bobby Dassey again in the same kind of a position to be his credibility to be weighed by you, but is an eyewitness, again, an eyewitness without any bias. It is an individual that deserves to be given a lot of credit because sometime between 2:30 and 2:45, he sees Teresa Halbach. He sees her taking photographs. He sees her finishing the photo shoot. And he sees her walking up towards Uncle Steve's trailer. Bobby would no longer be the quote unquote unbiased witness described about Prosecutor Kratz. Further, the forensic evidence would have been reviewed and planted, or at the very least tainted, by being in the hands of a third party. With the new evidence, the defense could have argued Mr. Avery returned to his trailer. Mr. Halbach left the property in her vehicle and Bobby followed her, got her to pull over, and assaulted and murdered her at some point. He planted the rifle on the Avery property and proceeded to remove and plant the electronic devices, the key, the bones, her clothing, her DNA on the bullet, and Avery's blood. The Sawinski evidence, when viewed in the aggregate, including all the false statements made by Bobby to law enforcement and at trial, would have provided a reasonable probability of a different outcome at trial. Number 3, whether the Court of Appeals improperly affirmed the Circuit Court's decision to deny Mr. Avery an evidentiary hearing. Standard of review. Whether a defendant's post-conviction motion alleges sufficient facts to entitle the defendant to a hearing for the relief requested is a mixed standard of review. The reviewing court determines whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief. This is a question of law that is reviewed de novo. If the motion raises such facts, the Circuit Court must hold an evidentiary hearing. However, if the motion does not raise facts sufficient to entitle the movement to relief, or presents only conclusionary allegations, or if the record conclusively demonstrates that the defendant is not entitled to relief, the Circuit Court has the discretion to grant or deny hearing. The reviewing court reviews a Circuit Court's discretionary decisions under the deferential erroneous exercise of discretion standard, State v. Allen. Mr. Avery alleged sufficient facts in his third 97406 motion entitling him to a hearing. However, the lower courts disputed those facts instead of taking them to be true. The circuit court, quote, must determine first whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendant to relief, end quote. State v. Ruffin. Citing State v. Allen, as with any other civil pleading in asserting the legal sufficiency of the motion, the court must assume the facts alleged therein to be true. Another quotation or another citation. Only after an evidentiary hearing is the court charged with determining the issues and making findings of fact and conclusions of law. And it gives a statute there. Both the circuit court and the Court of Appeals improperly attempted to weigh Mr. Avery's facts with speculative theories unsupported by the record, rather than accepting his facts as true and determining whether they were sufficiently pled to warrant an evidentiary hearing. The Court of Appeals offered the theory that Sawinski saw a different RAV4 and not Ms. Halbach's RAV4, as he claimed. Both courts failed to conduct any analysis of whether Mr. Avery pled sufficient facts to warrant an evidentiary hearing on his newly discovered evidence. Instead, the lower court weighed Mr. Avery's evidence as it had already been presented during the evidentiary hearing. When the lower court's analysis begins to weigh the evidence, it inevitably misstates and uncontradicted facts as a petitioner asserts are not taken as true. The need for an evidentiary hearing becomes apparent. Another citation. In Mr. Avery's case, each court has assumed as true a different theory or a different part of the theory than the other. No court has looked at all the evidence cumulatively to determine the likely impact of the defense or the prosecution's case or on the jury's verdict. Another quote, citation. An evidentiary hearing is nothing more than an intermediate step toward the objective of being granted a new trial. It is not an end in itself. The evidentiary hearing is a forum to prove allegations in a motion for post-conviction relief. See State v. Ballantyne. Mr. Avery's motion for post-conviction relief states what he is set to prove if were granted an evidentiary hearing. An evidentiary hearing would provide Mr. Avery with the opportunity to prove his pleaded claims that he is entitled to a new trial. If Mr. Avery's motion contained all the proof necessary to show that he was entitled to a new trial, he would not need an evidentiary hearing. Because Mr. Avery has alleged sufficient facts in his motion that, if true, would entitle him to relief, yet the lower court keeps denying him the opportunity for an evidentiary hearing. Mr. Avery asked this court to revisit what is required for an evidentiary hearing. Conclusion. Petitioner Stephen Avery's case raises three critical issues on which this court's guidance is needed. First, Mr. Avery presents this court with an opportunity to correct the lower court's misrepresentations of law and what is required to bring forth newly discovered evidence. Second, Mr. Avery presents this court with an opportunity to return to the issue of extent of motive, opportunity, and direct connection that is necessary to satisfy the Denny third-party suspect test for admissibility. Third, Mr. Avery presents this court with an opportunity to correct this lower court's misrepresentations of the pleading standard to obtain an evidentiary hearing on Mr. Avery's claims. Fourth, Mr. Avery presents this court with an opportunity to grant him a new trial in the interest of justice. Petitioner Stephen Avery respectfully asks this court to grant him leave to appeal the issues raised herein. And that's it. We made it. That Zellner and Steve Richards. I'm not sure. Okay, clarification or certification as to the form and the length. Yes, like I said, I knew that there was a. And then certification of compliance and the certification of compliance with the rule 809.19. Alrighty. Well, I think she pretty well laid it out. I don't know what you guys think, but I think without a lot of overly complicated things that we've gotten into in other briefs and so forth, this is pretty straightly laid out brief, or whatever you want to call it, as it was presented to the Wisconsin Supreme Court. And again, I know very little about how they rule, what effect this the changing of the guard, as it were. There's another election too. I'm sure everybody's aware of that. The parties have changed. The ones in control. Again, I have no idea how that's going to affect their decision process. One party being in control versus the other party, it may not affect it at all. Right? I just don't know. So I guess any thoughts and feelings about that, you guys are certainly welcome to make. I'm sure we'll be seeing things on social media, which has had a great impact on at least many of the public, the ones that are on two different sides of the case. Thought this would be an interesting end picture, one that we don't really look at very often. Hey, there's Raven. What's up, Raven?
Hey, how you doing? I'm super late because I had no idea actually y'all were even doing this tonight. I was pleasantly surprised. I got to listen to some of it on the car ride home.
Yeah, well, it was kind of late last night for everyone. Don't really do. We've done a few earlier in the day over the years, but not many, especially when you were reading these briefs and so forth that Zellner has presented and the state's replies. We generally do them in the evening time,
Right.
kind of a balance between the Australians, which are they're in the future. I keep trying to get Doc to get me lottery tickets. He
Right.
won't do it. And then we have our European friends that it's late as hell for them. Well, not for Alice. It's really early for Alice. We keep her up really late when we have a chance. So that this 5 to 7 p.m. Eastern time is kind of somewhere kind of in the middle. So
yep. Yeah, I was gonna try to help you read some of it, but did you already get through all of it? I see pictures now on the screen.
Yeah, it's done. It's over. Okay. It wasn't that long. I mean, really, literally, probably 22 pages, I think, or 23 pages of actual.
Right. Yeah, I think it was 31 pages, but then you're right, like 8 pages are just fluff and
right.
Yeah. I still haven't got to read it yet.
Yeah, I mean, she just pretty well laid out the overall. Not. I mean, a little bit of the detail, but nothing overly complicated. And she feels like the circuit court, which I do agree that Judge Angie's requirements are over the moon. I'm probably going to try to do that tomorrow night, read Judge Angie's decision prior to Zellner appealing that, and of course the decision that the Court of Appeals made, but to reread and break it down again. We broke it down pretty good the first time we read through it. It's pretty fantastic, the requirements that she laid out. Again, I'm not sure you heard my comments that, if we take the Sowinski affidavit as true, his statements as true, anyone being possession of that RAV creates a real problem for me. It can't be ignored just by saying, well, no one saw Bobby with her keys, her phone, her Palm Pilot, so therefore it doesn't matter. I can't agree with that. You need a hearing to hash it out, one way or the other. Have the hearing and see where you get with it.
Yeah, no, you'd have to look at it more closely for sure. If some kind of proof came out that somebody else had the RAV, you'd definitely have to. Like that's even more so than like I know I saw on the Discord right before I got here. I think they were talking about like if you could see the RAV on the property when they did the flyover or not. But like it would be. I mean, both are concerning. If it wasn't there, you might have to look at it. You might have to scrutinize it a little bit more for that. But what you're talking about, even more so, because if it's not there on the 4th, all right, whatever. Devil's advocate, you can say Avery didn't put it there till the 5th, the morning of the 5th, or something. It could still have been Avery. But what we're talking about here, if there is proof that somebody else had the RAV2, that opens up a lot more doors, because that could be that maybe Avery didn't do it, or maybe it was Avery plus somebody. Like there's a million doors that it could open for that, even more so than not seeing the RAV there on the 4th.
Well, I mean, hey, kitty cat, meow.
Yeah.
Let's show the kitty cat. Hold on here. There we go.
Yep. I get home, and of course they know it's dinner time, so I have about probably 30 minutes before they start eating me.
Yeah, we've got 2 cats, and one of them, she's a 16, 17-year-old calico, and she doesn't really care, what I'm doing or whatever. She's like that cat, just jump up and do whatever.
Yep.
I'm here. That's all that matters. So pet me.
Yep.
Yeah, they're great. But another problem that is also presented is the phone call from Sowinski that was suppressed until 2022. That's a problem. There's still the November 4th calls we still haven't got. That's another problem. She doesn't really raise that. I'm not sure she raises it. I can't remember if she raised that anywhere in any of her filings, but
which November 4th calls are you referring to?
From Manitowoc County Sheriff's Department. They have never produced a call from November 4th.
Okay. You're just talking about a single MTSO call from November 4th.
No,
okay.
I'm talking about any.
Or that's what I mean. Yeah, that's what. Like they haven't released a single call from that day, is what you're saying.
No, that's right. And they've been requested numerous times.
Interesting.
And
I don't know what the reasoning for that would be.
Hold on just a second.
Because you guys have a bunch of them. You guys have a bunch of the other ones. I mean, I've seen at least probably November 1st, 2nd, 3rd calls, stuff like that.
Sorry about that. We've got. I won't say we have all the calls. We have all the calls that have released to us so far.
Right.
Rookie got the Manitowoc County. Just a little history. Rookie got the Manitowoc County Sheriff's Departments. He got 13 CDs, DVDs back in what was it, 2019.
That was the guy who went on cam, right? Andy?
Yes, that's correct.
Yeah. Okay.
However, there are 35 or 36 CDs. He found that out at some point that there was 22 or 23 more CDs, DVDs that Manitowoc hadn't released. Anyway, that's when records custodian Larry Ledvana was there. He retired at the end of 2021. Major Tom Cummings, I think he's a major, he took over as records custodian at Manitowoc, and within 2 weeks of him taking over and getting his feet into the ground, I don't exactly remember what month it was, but irregardless, he found 23 22 more maybe CDs, DVDs of calls that had not been previously released. So the Sowinski call was part of that.
Yep.
That's a real problem because if this guy walks in and he's got his hands on it within a couple of weeks, then I mean, for me, just looking at it reasonably, we've got a problem. Now, around the time that Rookie got in 2019, summer, early fall 2019, when Rookie got the original 13 CDs, Seeking Truth for Good got the Calumet dispatch calls, which is one CD. There's 18,500 or 600 files on that CD. They're all zipped up, but I mean, the bulk of them are pretty irrelevant. But there are several dozen that were released that are important. They raise other questions too about what all was recorded in that system and what was withheld. I mean, we certainly have calls that indicate some of these, well, that basically all of these these various officers like Poggle and Captain Rush and several of these officers and detectives had their own office, and these calls were recorded within the system, but we don't have all of them. We've only got part of them. And I you know,
Right, and
I
you don't
doubt
know the
that.
reasoning for that.
Well, I don't think they'll ever release the rest of them, no matter what. I mean, I've got an open records request in with Calumet that I filed in June 3rd, 2024. Still don't have it. It's literally just burning CDs. Literally, just that's all they got to do. They've been released before, but I asked for a specific thing, and last reply I even got out of them was in August. It's your request is being prepared or whatever. That's the last thing I've heard. And I've sent numerous requests for status update. Nothing. Got several in with the DOJ. That's talking. They've also stonewalled me, which you wouldn't think a state agency would, but they have. For me, Raven, that's a problem. There shouldn't. We're almost 20 years into this.
Yeah.
This case. What's the problem? Just if there's nothing there, just release it.
Yeah. No, I can understand that. Yeah.
So, hey Crockett, thanks for dropping by. Really appreciate it. Hey, we got Lola Blue Skies. Haven't seen Lola in a while. Insomnia, yeah. Malta MT. I'm not sure where that's at.
Yeah, I'm not.
It doesn't ring any. Yeah, that doesn't ring any bells. Anyway.
Oh, Malta in the Mediterranean, I think.
Oh.
No, wait. Or it could be Malta, city in Montana. Actually, the MT, that probably means Montana. Yeah.
Okay.
I was trying to think quick back to social studies class real fast. I was like, MT, what state is MT?
and they're probably in Mountain or Pacific time, so they're even earlier than I am. I'm in Eastern time zone. Okay, let's see what Travis got to say here. The Wisconsin, I guess he's meaning the Supreme Court, either accepts discretionary reviews or denies discretionary reviews. Last time, they denied the discretionary review. Bones computer, they did. And she applied the last time. What did I miss? Well, I read out Zellner's brief, or whatever you want to call it, to the Wisconsin Supreme Court, appealing the Court of Appeals decision to see if they will take the case. They're not required. They have discretion to listen to whatever cases they choose. I don't know that I agree with that approach, but hey, what do I know? I think if it, if a lawyer, I mean, I guess they would, probably get inundated with cases, but I'm not, legally scholarly enough to really talk intelligently about that and make a good argument. But to get to that level, I mean, you're already, circuit court, court of appeals, and that's the third step. I don't know. That's for another discussion with people that are smarter than I am about the legal kind of thing. But anyway, I thought it was pretty well laid out.
This is the first time it's made it to the state Supreme Court, isn't it? I'm
No,
not.
she
No,
she
hasn't.
she did it. No, she did another one. She appealed to the
Was that
Wisconsin Supreme.
17 or 21? That I knew it was. I knew if it was before, it was either one of those. I think, right? It was either 2017 or 2021.
Probably 21. When the
21.
Court of
Okay.
Appeals, when the Court of Appeals denied, but they refused to hear the case. They passed. Yeah, that's okay. I knew that's what you meant, Travis. Wisconsin Supreme Court. But I think overall that, again, I think it was pretty well laid out. I didn't see anything too wordy or too extraneous. She did cite several cases. Clearly, I don't I don't know those cases at all, but they're there in the index for anyone that wants to look them up that she cited. That's a great question, Doc. What do you believe Casey's chances of a hearing? Well, I know where I put my vote, Doc. I know what's happened in the last, 8 years. It's pretty much down to around 0. But at the same time, again, this changing of the political thing in Wisconsin, I don't know how that's going, if it'll affect it at all. They pretty well linked arms in the Wisconsin judicial about this case, and made some pretty extraordinary rulings. The Bones, the Bone giveaway in 2011, they just come up and say, well, it's inexplicable. I was talking to Susan the other night, and she said that she had seen that one other time, or maybe a couple other times in other cases too, where an event's happened that shouldn't have, and they just blow it off as inexplicable, like that's a legal term. And I'd never heard that before, never. That's how she got her nickname in it.
I just put that together. Yeah, I was like, okay.
Yep, that's how she got her nickname. It's crazy how they did that.
I'd be curious to see. I'm gonna have to ask her like what the other examples are. Now I'm just curious now.
Yeah, it's
the other
couple.
cases.
She keeps up with a few other cases.
Yeah,
and
no,
she
we've
said,
had discussions about a couple cases now. She seems to be a true crime fan, just like I am. Like pretty
oh
general,
yeah,
pretty open. Yeah.
yeah, absolutely. But I don't know if it was. Well, I don't know what cases. She probably told me, and I don't remember. Yeah, Travis has got it here for us. 2021 Court of Appeals denied all issues except the issue that they're up on now. They especially said she could bring a separate appeal, which is this one here. Yeah. Yep. She did exactly what they told her, and they denied it. And they did go. They basically, the Court of Appeals, like we all know, they agreed with the decision Judge Angie made with, and I can't force myself down that road. But again, I don't see what they see. I don't know what they know. So,
did that new judge have anything at all to do with the most recent everything? Like, remember that was the new rage, was that the case was getting a new judge, and then like only a week after that we realized, wow, there's going to be a decision come in about the appeal, and then
no.
and then the appeal came in, and I haven't heard anything about the new judge since.
Well, as far as I know, the only way the new judge comes in to play is 2 different ways. If the Wisconsin Supreme Court says, "Yeah, you're going to have a hearing," it would go to his court.
Okay.
if they deny it and Zellner files another 974 on whatever, which I don't know what that would be on, it would go to him.
Okay.
Other than that, this decision here is strictly on what the Court of Appeals and
Right,
Judge
and then the
Angie
Supreme.
decided,
Or,
and then now to to
yeah.
see if they'll take the case.
Yep.
So
Okay.
I think they had a short phone call with all the lawyers involved in the case with that new judge to maybe fill in a few blanks. I think it was a relatively short call, as I recall. I don't remember how long, but I don't think it was anything lengthy. He had maybe he has specific questions. I think I know what it was. He was asking for material, and they told him, whatever you need.
Yeah.
Just
Okay. Yep.
so. Travis says, sadly, the 4-3 switch will not likely impact things. They didn't get a single dissent in the Wisconsin. Yeah. And that's what I recall too. That's why I'm saying I just don't know how that could affect, if it'll affect things at all. I suspect it won't. But yeah, that's pretty much it. I don't know of any. There was nothing extraordinary in this. She just laid out what she saw in the Judge Angie's decision, the Court of Appeals decision, to see, and she says now they're incorrect. They misapplied statutes or the law or whatever. Please correct this. Give us a hearing. That's what I get out of it. I will add a link to the document. I forgot to do that last night, but I will add a link to the document in the description for anybody that wants it. Travis says the new judge had a state conference and wanted to confirm that there wasn't anything he needed to do. Both sides, KZ, Tom Fowler were on the call. Said, nope, nothing to do. We will send you what you want. Yeah.
Okay. Yep. I thought I'd heard that. I just didn't know if maybe he commented on any of the recent stuff with all this or not. But okay, interesting.
No, I haven't heard anything. Of course, we got the Dave Remiker thing.
Yeah, right. I haven't heard anything about that either since then. So
no, I think
yeah.
I think there's nothing. I think there was a preliminary, or not a preliminary, but my mind just went blank. He pled not guilty, whatever that.
Right, a plea entering. Yeah. I can't think of the actual legal term of it right now.
Initial appearance. Isn't it called the initial appearance?
Might be, yeah. Easy, soon.
So anyway,
what is this, or when is this rather picture on the screen from?
This is, let's see if it's on here. Scroll that down. See if I can get it. See if the metadata is attached. This is January 13th, 2006 at 2:47 p.m.
Okay, January of 06. Okay.
Yeah, I'm not entirely sure what they're doing. They're clearly in the back, looking at something. But again, this is a photo we don't really see much of. We've got them. They're not like hidden or anything, but they've had the vehicle in this crate. But it's interesting to me that all the evidence tape has been tore off of it. The doors are not sealed. The back is clearly not sealed. The only thing that is really apparent is the evidence tag that's on the windshield.
Right. You're judging the lack of evidence tape from previous pictures that were from before this with it on there.
Oh yeah, when there are other photos that
right. Like when they took it in November, they probably the photos could have been from November or something, and obviously this one here being later.
I don't remember when those photos were taken, but there's evidence tape around the doors. And then there's pieces of red tape where they found something was indicated, or not red. Well, yeah, there's some red tape, but there's also some white tabs that they put on where they see something and it gets tagged. Of course, these you can't really see around the back. I think there's one more in this group here, and there's that one, and then there's a few prior of the interior.
Okay, yeah. Nice. I've never seen these pictures before, actually.
Yeah, they're in the photo section. There's let's see, in that folder, there's 67 photos. I mean, yeah, they're irrelevant, basically. I mean, it gives you a view, but
yeah, right.
So, yeah, I thought it was an interesting photo. I don't know what you can see a little something here on this frame.
Yeah.
Looks like some white tape that's not been all the way removed. But yeah. Anyway, that's all I've got. Unless there's some questions out there about this or something else anyone wants to discuss. I haven't really seen any questions, so I guess this is a little bit of what it's about, but it's basically just reading this document. I'd read a little bit of it. Oh, well, Crockett's already gone. I missed this one. How does the Wisconsin Supreme Court?
Probably means how long does.
Yeah. And I don't. Maybe Travis can answer, but I don't think there is a date. I don't think they're tied to a date like the Court of Appeals. A reasonable amount of time, I guess, is the And then 2Rev says what dates are missing from Teresa's phone records. Well, without I can't really answer that because I don't have a log of what all calls she's supposed to make because we don't have a full. I mean, we have that generated list that Zellner got where she got this record of calls from when Teresa had Verizon and then moved to AT&T and everything, or Singular, and got ported over. But without an actual bill, final bill that's supposed to contain all calls, et cetera, I don't know. I can't answer that. I just can't. It's kind of like saying what calls were missing from Manitowoc Sheriff's Office and or the Calumet Sheriff's Office without an audit log that details how many calls, like Calumet, their stuff is divided up into 15 channels in that system. And basically 4 of them, well, 3 really, are used by really often by the Sheriff's Office. That's Channel 6 and Channel 7. And then Channel 1 is radio traffic. But there are other channels that are also tied to law enforcement. But without an actual audit log of every call made, well, I can't answer it. There's just no way. You don't know how many calls came in and at what time and to who. There's no way to track it. I mean, it would be pretty cumbersome list to go through, but to really answer any of those questions, that's what you for Teresa, you'd have to have a final bill that she would get in the mail to pay each month to see what all calls that she actually got for that month. Because if you look at this partial bill that they subpoenaed, that the state subpoenaed of Teresa's calls for this short time frame, it says at the bottom it's a partial. It tells you that some calls may not show up that actually happened until the final bill is given to the customer. I thought that was interesting. See if I missed anything else. I tried to keep up. I apologize. 2 different screens going. Yeah, I think that's all. Yeah, okay.
Paul Ward mentioned something I thought was interesting too. He asked why preserve the RAV4 for future testing if they don't let Kathleen Zellner test it. I think if I'm not mistaken, in most, if not all cases, the evidence is only saved for a certain period of time, and then it's only saved longer if you file a motion to preserve it. Am I correct in that? Do you happen to know?
Well, maybe in some states, but in Wisconsin, there were 2000. I think it passed in 2001,
Mhm.
2000. Any biological evidence used to convict someone has to be maintained
Really? Indefinitely?
indefinitely,
Interesting.
unless the state gets permission
Ah,
from the
okay.
defendant to destroy it or give it back or whatever the case may be.
Ah,
That's why
okay.
the
There we go.
that's why there's such a flubub about what they did in 2011, giving all these cremains back.
Right. Yeah. Interesting.
Uh,
I wonder
yeah,
how many states share that. Uh, not really
no,
law, but like just
it actually is
is it
law.
a law? Okay, so then
Yeah,
I wonder how many states or how many states share that law. Interesting.
I don't know. I would imagine several have something similar on their books because of the advances of it was done that they did this for the advancement. They knew science would advance and better testing would be available in the future.
Yeah. Right.
Gone was
Yeah.
part of that. They got that done.
Right.
That's so ironic.
Yeah. It just seems for, me, I mean, I look at the statistics all the time. I mean, unfortunately, US is very high in the murder rate department. And so like I can only imagine how much evidence, and how there must be out there, and then to save all of it seems like where are they putting all this stuff? I don't
Well, no, that's a fair assessment
Yep.
because the state has to, they're in control of it. They have to
Yeah.
maintain some
Yeah.
facility, that's secure,
Yeah.
dry, maybe even climate control for some of this stuff.
Yeah. Yeah.
Like blood has to be stored in a cool area. Other biological evidence may have to go into some kind of freezer or whatever to
Yeah.
be maintained. So yeah, it gets complicated, and I'm sure not an inexpensive thing.
Yeah.
Depending on so what this raises questions about what happened in 2011 because again, this law was in full effect and when this event happened. I'm sure the Hallbucks were told the biological evidence can't be given back. Or why wouldn't they just given it back immediately? And then they come up in 2011, there was some kind of contact made between the state and the Hallbucks. I've asked twice, I've asked the DOJ who initiated that contact, and they won't. I asked for any and all communication, and they denied my request. They didn't say, "Hey, there's nothing there. We don't have anything."
Right. Right.
They outright denied my request,
Hmm.
stating, "Well, it would have to be something Travis could read. I can't." They're
Right.
citing all kinds of different things.
Do you think, in your opinion, it would be more likely that they would give you that answer if it were the Hallbox requesting, or or if it were the Hallbox starting the conversation and all that happening, or if it was the state starting all that and having it happen?
Well, yeah, I think that if the Hallbox initiated that conversation, that's much less of an issue.
Right.
If the state initiated the contact, you got a problem.
Yeah. Yeah.
So, well, that's kind of the thing, Yoga. Yeah,
Oh, not that. I was laughing at Danny's comment. Or you can just put evidence in the clerk's office closet.
yes, that's true.
I wish I could tell. I don't know if you live in the States or not, Danny, but I wish I could tell you like some, especially back then, like, even, I mean, I'm sure before that too, but like 90s and even early 2000s, before we got like all teched up, and we were able to keep track of stuff better, it was a wild house. Like there's a lot of that kind of stuff that shouldn't have been going on. I'm just going to be real.
Oh, absolutely.
Yeah.
Well, I think Danny actually lives just right around the corner there in
Oh,
Wisconsin.
yeah. Okay.
He's nearby. I think he's a local nearby.
Where are the Brewers from? That might help answer. I don't know the Brewers. It must be either a hockey or a baseball team. Those are the two sports I don't follow here.
I think the Brewers are a baseball team.
Okay.
Pretty sure that's right. In like a semi pro
Yeah. Does Milwaukee Brewers sound right? That sounds right to me, maybe.
could be.
Or
I don't really follow, but I mean,
yeah, I'm not a
I watched the
baseball guy,
yeah I
but
watched Detroit Tigers a little bit, but
Milwaukee Brewers. Yeah, I was right. I don't know why. I just heard that somewhere. And okay, yeah.
you know this excuse that the state came up with. Well, his direct appeals was done, but that doesn't take away from the 97406 motion at all. And Fallon was well aware of that, and so were the Gone. He was well aware of the 97406 potential as well. So that didn't really fly for me. Um, just try to say here for me to read the Hallbox don't need to do open record requests. They can call a victim witness coordinator or contacts an ADA, Assistant Attorney General, who will get them answers. Always works that way for victims' families. Yeah, I'm sure. Yeah. Um, I don't. Again, I don't know what went on, but something clearly weird. 4 years after the fact, something weird happened in 2011, and that was another one that was just glossed over. And let's just move on. It's inexplicable. Thank you. Which I think is wrong. But hey, what do I know? I'm not a lawyer. Just looking for the truth, man. I just want the full story. That's all I want. The full
Yep.
story.
We're all interested in it. I mean, that's why we're all here.
That's right. That's exactly right. So anyway, Raven, unless you got something else, I'm going to. We've been here a couple hours now. I was a couple minutes late, but been here a couple hours and change. So unless you've got something, I'm gonna ease us out the door.
All good. Thanks for having me.
Hey, anytime, man. Anytime you want to come in and chat and participate, absolutely. I would definitely love to have you help read because
Yeah, no. If I could have, I would have.
I know. Well, I mean, I just with this kind of stuff, I like to divide that up so
Yeah, no, it
different
helps.
voices,
It helps. I'll lose
different.
my voice if I read too long for out loud too.
Well, it's not only that, but it gives a different voice, not necessarily to let someone else's voice rest, but a
Yeah, right.
different voice for inflection and maybe even raise other questions.
I
So
can understand that.
so tomorrow for the open mic, it's going to be. I'm probably going to do it at the same time, just to say keep it even. Say it's going to be 6 o'clock Central Time. I'm going to read Judge Angie's decision and order leading up to KZ's appeal to the Court of Appeals. Again, just for our clarification, it's been a while, been a couple of years since we read that out. That way, it might give us a little bit better insight going through it again and then basing on what the Court of Appeals did. So we can talk about that for a minute. Yeah. Yeah. Thanks, Doug. Definitely hit the like button. If you haven't subbed, I always appreciate a new sub. Always put your comments in the comment section after the video processes. We'll try to get to as many as we can. I apologize. I've not been able to lately. I've got stuff going on in real life with Mrs. Jack. She's doing better every day, but it's still a process. So um, everybody's got something going on right now, man. It's been crazy. It's but for we're just regular people like everyone else. Real life always comes first for us. If somebody has to step away, it's just a given. There's no you can't go anywhere. We got to. It's never been that ever. Got stuff going on. Go deal with it, man. It'll be fine. We'll do something else. So anyway, um, really appreciate everyone coming in, listening, comments, good conversations as always in the live chat. Uh, comments in the below when the video processes, and we'll see you tomorrow, 6 p.m. Eastern. I'm sorry, 6 p.m. Central Standard Time. With that said, I'm going to tell you this has been a Foul Play production.